Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Rausan Pereira. The Supreme Court on Wednesday upheld the validity of India's ambitious biometric identity project Aadhaar, saying it benefited the marginalized and poor, but sharply reined in a government push to make it mandatory for various services. In a ruling with far-reaching consequences, a panel of 5 judges cleared the use of Aadhaar for welfare schemes, saying it empowered the poor and marginalized. A majority of the panel ruled the program had merits, but struck down provisions in the Act that made its use mandatory in applications for services ranging from bank accounts to mobile telephone connections and school admissions. The court also ruled unconstitutional the use of Aadhaar by companies to establish an individual's identity. On this edition of The Big Picture, we will analyze the Aadhaar verdict. Joining me on the program today are Deepak, Advocate of the Supreme Court, Shubhamoy Bhattacharjee, Consulting Editor of the Business Standard, P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India, and Nikhil Dey, social activist. Thank you to all my guests for joining me on this edition of The Big Picture. Mr. Malhotra, I'd like to begin with you. Your thoughts on the verdict?
I think it's a welcome decision. All of us should welcome it. And it is necessary to understand the background in which this decision has been given. And fortunately, the majority view has discussed all those reasons. The process of registration under the Aadhaar started way back in the project was conceived in 2006. Government deliberated on it, consulted all other people who were concerned with the subject, and in 2009 it came out with an executive order by way of a government resolution whereby the UAID was constituted. Under that, there was a specific provision that this unique number will be utilized only for the services which Government of India will be providing, so that whatever loopholes are there and the provisions of subsidy or the financial assistance or other assistance being given by the government is being misused either by the non-existent person or by the intermediaries, they should be removed, and the benefit of all those schemes should go to the individuals. The challenge was made way back in 2013 when it was regulated by an executive order, and the main challenge was that the right of privacy is violated because this is being regulated by not by an act of parliament but by an executive order. Secondly, because the data has been collected by the private agencies, there is no provision for data security. And thirdly, in case anybody is misusing the data, he is not utilizing the data for the purpose for it has been collected, probably there is a likelihood that there is no provision that he can be prosecuted. So to cover all these aspects, and mind it, because the resolution was already under challenge, in 2016 when the parliament made law, it took care of all these aspects. And therefore, the Supreme Court, after discussing all these aspects, had come to the conclusion that the benefit for which the Act has been passed, I think that objective is well achieved by the provision of the Act, and therefore its constitutional validity has been upheld. Only 2 or 3 provisions have been touched where the data can be shared by the private agencies, that is one, and with regard to banks and other agencies which were not necessarily mandated under the Act to collect Aadhaar data, they have said they cannot collect it. It is only for the purpose of section 9 where benefits are to be drawn by an individual, then this benefit will then only the provision of the Act will be applicable and registration of Aadhaar will become compulsory.
Right.
In addition, the more importantly, the Supreme Court has given a direction that now the government must come out with a strong data protection law also, in addition to the safeguards which have been given under this particular Act. I think with these safeguards, the judgment should be welcome, and the kind of difficulties which we are facing, that everybody was insisting that no, you provide your Aadhaar data, probably that kind of insistence by the private agencies, those who under the Act are not authorized to collect this data, probably they will not be allowed to collect that data, and there will be clarity in this situation.
Right. Deepak, was this on expected lines, do you think, especially after seeing what the Sri Krishna Committee report said about privacy and about data and all those aspects?
To some extent, I think this was expected, but I think there are some very fundamental issues which have been raised and addressed. both in the majority opinion as well as the dissenting opinion of Justice Chandrachud. Frankly speaking, I think the judgment runs into 1,448 pages. I can't claim to have read it, and I have not entirely. It just so happens that I was in the court when the pronouncement went on for about 1.5 hours until 12:30. So I had some occasion to listen to everything that was being said, including of the operative portions. So I think there are three baskets that I think we'll have to split this issue into. The first basket goes to the issue of constitutionality of the origins of that bill itself. Secondly, can the court get into the question of judicial review of the certification of a bill as a money bill by the Speaker, followed by the constitutionality of the Act itself, and then you get into the question of the safeguards that are provided in the Act or which are absent in the Act with respect to privacy, so on and so forth, and the balance that the court has tried to strike between what it calls as the socio-economic rights of the marginalized people as part of Article 21 as part of human dignity, and the parting of minimal information that is needed for extension of benefits or incentives. Before we get into the other two baskets, the first basket according to me is the most important basket, because one of the central questions which I think both the majority and the minority views have grappled with is, can a bill which has been disguised as a money bill, can you then sit over judicial review of it with respect to the provisions itself as opposed to sending it back to the Parliament if you believe that this does not qualify as a money bill within the meaning of Article 110 and therefore requires to be sent back? So they answer the question in the affirmative with respect to the power of the judiciary to look into this question of the certification of the bill itself. So both, I think the majority and the minority views take the clear position that the court has the power to look into the decision of the Speaker when it comes to whether the bill was rightly certified as a money bill or not. On that particular issue, Justice Chandrachud's opinion, I think, is a stellar read from what I was able to gather during the course of the pronouncement, where he clearly says that none of the provisions of, let's say, 110 from A to G are completely satisfied by this, because this act is not entirely about a tax related legislation, and therefore it goes much beyond that. And therefore it cannot be used as the route to prevent any kind of review by Rajya Sabha, which has very limited say when it comes to a money bill. So this, I think, is where the entire issue. So according to him, if this issue is held against the Act and the passing of the Act, wherein he says that structural due process is violated, then there is no need to get into a further debate with respect to the constitutional values of the provisions itself, and therefore it has to be sent back. Having dealt with that particular issue, he then goes into the questions of the multiple provisions. So as far as I am concerned, it raises two things. If you come to the conclusion that this bill or this Act cannot be given the benefit of a money bill, why do you need to go a step further and look into the rest of the thing itself? But here's where there is a different thing that plays itself out. This writ petition was filed by Justice Puttaswamy in 2012, 494 of 2012. And from then on, the implementation of this particular project has been massive across the board. Optional or otherwise, a lot of money has been spent and a lot of water has flown under the bridge. So how do you turn the clock back? Then the question is, when the central question of constitutionality of the structural due process itself is in question, apart from issues of privacy, could you have or should you have allowed the government to proceed with this, its implementation, knowing fully well that should you strike down the Act in entirety for, let's say, a colorable exercise of powers by the Speaker, let's say that's the issue there, then what do you do with the entire infrastructure that has been put in place and all the taxpayers' money that has gone down the drain? So that has necessitated, according to me, a situation where you have had to uphold the Act to a certain extent as well as its implementation.
Compelled to do so, you're saying.
I would say so.
All right, Nikhil Dey, that having been said, what implications is this verdict going to have really going forward?
So it's to many of us who worked with the poor and who work on welfare benefits, which was the original touted objective of this act, that it was all supposed to be for better delivery. It's named so, targeted delivery of benefits. It's a deeply disappointing judgment. The reason is that while this court says that it is upholding Article 21 of the poor, there are huge numbers. This is not the 3% the court says who are out of Aadhaar. Out of the 97% who have Aadhaar, those are the people who, because of Aadhaar, are not able to get their benefits, and their Article 21 rights are being abrogated by Aadhaar. That was the constitutionality that people like us, who were petitioners also, were challenging. How can you keep someone from not getting their rations or their pensions or their Narega wages, which is their survival, because of Aadhaar. They are otherwise entitled. They have met all other criteria. They are not false. They have an Aadhaar card. Today, over the last year in Rajasthan, and very few people know it, and unfortunately the judges did not acknowledge that, you have to use your biometric to get rations. And actually Aadhaar is biometric, it's little else. That is their one robust point, the only one. That when you use your biometric, then you know you are you. You can authenticate. 20% people are not able to, those who have Aadhaar and who are National Food Security beneficiaries. They are not able to get their rations. Many of them have gone into malnutrition. Many old age pensioners who get 500 rupees pension, we have seen them dying. There are 56 cases that the food campaign, Right to Food campaign, is taking around, documenting, many of whom have Aadhaar related deaths. Now, who will answer for that? And that is why we were saying that this is something primarily from the point of view of delivery of welfare benefits. It is actually, if you make it mandatory, it's doing the opposite. Now, the court, what it said, if it were optional, then obviously people who are empowered by Aadhaar to be able to say, this is me or I don't have an identity, would use it. Then those who were being prevented would not use it and would use some other identity. Now, the court has said nobody can be prevented and there should be safeguards. We have seen safeguards. We have seen safeguards over these many years. We have seen this being unrolled. And people like us who have fought corruption, fought everything else, you cannot, under the guise of just corruption, which is, by the way, still continuing in many other ways, you cannot say that someone will be prevented from their benefits. And that's what's happening. And there are no safeguards. There is no one. You have these single lines saying nobody should be kept away from their benefits. What does that mean? And that's a life and death question. That's an Article 21 question for those people. So that, to me, is one very, very important point. And it's important on English speaking programs, because people who speak English don't realize what it is to go out there and put your calloused hand and go out there. In Delhi, we are unable to get mobile connectivity all the time. So it's not just a question of Aadhaar or my fingerprint working. It's also a question of that machine being able to send internet messages back and forth. And if that doesn't work, people are kept away from their rations.
So the ground reality is very different, is what you're suggesting.
Yeah, and it is not just a small technicality.
Right.
It hits at the basic thing. If I don't get my food, it's my right to life.
Yeah. Point taken, and they are very valid points, and I think that these issues should be looked into at the end of the day. Let me go across now to Shubhamay Bhattacharjee. Shubhamay Bhattacharjee, what changes now?
Well, essentially, when Aadhaar was created, the idea was that Aadhaar would basically be distinct from the National Register of Citizens. You know, the National Register of Citizens was supposed to be citizenship. This has been meant to have been created during the UPA government as for the delivery of welfare benefits. There was no other reason why the UIDI, why the Aadhaar system was created. If there was surveillance, the surveillance was supposed to have been coming through the NRC. And that was clearly discarded by the UPA government, that is not something we are looking at. If we are, the court today upheld that basic premise, that it is a mechanism which the government can and should be using for delivery of welfare benefits. I agree with Mr. Dey's point that there are lots of places in India where connections don't go through. But I am surprised that he's saying that Aadhaar doesn't work, because what the implication is that the PDS system, which exists in all parts of India, was actually working beautifully before this. And if that is so, then I think we were actually in a situation where that means the food security in India was actually working wonderfully well till Aadhaar came in and interrupted it. I'm not saying that Aadhaar is the best, but I'm definitely leery about a suggestion which says that if you remove Aadhaar, interventions by good intentions would actually end up creating a much better ecosystem of benefits than it was possible otherwise. The one problem, leaving that out, one problem that I'm concerned about is that Aadhaar says it will not, and I'm happy about that Aadhaar says that private agencies should not be getting into the state-created database, which I think is a very well-made point. what will be the impact of this on the financial sector, where we are really grappling with corruption, and the corruption where it is almost often coming to the question of identity. Let me tell you the question of shell companies. In shell companies, the directors and others, they have been weeded out simply on the basis of Aadhaar. There was no other way in which you could say that this person is this person. That entire exercise now actually is frankly open to review. Somebody who's been weeded out now can jolly well say that, that since the court has said this, therefore I cannot be removed of my facilities. So I don't know how this would play out. Probably Mr. Deepak would be able to say future going along. But I would think the implications for the financial sector would be very interesting to figure out going ahead.
Indeed. Yes,
I think
Ms. Malhotra.
basically we are deliberating on two issues which arise out of this judgment. One is the Aadhaar scheme itself. Another is the implementation of the scheme as such. I think this court has ruled on the scheme as such and legality of the scheme. So far as the implementation part is concerned, the court itself has taken into account the various factors which have been highlighted here. And it was said that so far as the authentication system failure is concerned, the percentage is very low. If you are going to implement a scheme at such a large scale, obviously you can't expect perfection from day one. It will take certain time for the schemes to settle down. And in that process, yes, there is a possibility some people might have suffered. Only thing is how quickly you can cap it and perfect the system, that is more important. I understand recently Finance Minister has made a statement that after implementation of the Aadhaar in subsidy and other areas, the government has been able to save 90,000 crore, which will be utilized for the benefit of the marginalized people. I think that itself is an achievement.
Right. So the pros outweigh the cons is what you're suggesting.
Exactly.
At the end of the day. These are teething problems. They need to be addressed on the go.
Precisely.
Desai Deepak, another aspect. Now private companies, banks, corporates cannot ask for Aadhaar anymore going forward. What happens to those companies who already have all our details?
Honestly, the consequences or the implications of this judgment on data which I've already parted with some of these entities, I still am yet to figure it out, because I want to see what is it that the judgment has exactly said with respect to these aspects, and what happens to transactions which are concluded. And as Mr. Bhattacharya rightly points out, what happens to certain consequences that are visited upon people as a consequence of the implementation of the Act, and with respect to any provision that's been struck down. I don't know. I honestly am not aware of it, because I want to see what the court says with respect to any pending matters or concluded transactions. That's point number one. Point number two, the one thing that I think is extremely important to emphasize upon is the point made by Mr. Malhotra, which I think is the best point that one could have made. That is, strike a distinction between the legality of the legislation and the operational issues that perhaps plague the particular system. Because it can't be our case that unless and until a system works 100% and it reaches out to every person in the particular community or to every person who forms part of the target audience, then it is otherwise unconstitutional. That's not the argument. And the percentage that the court was concerned with was 99.76 and 0.23. So the court said that do consider the fact that if for the purposes, or if you consider that for 0.23% who are excluded, the entire act must be struck down, then the 99.76% who are the beneficiaries of the particular system also get excluded from the system. Therefore, a balance needs to be struck. You are therefore looking at the greater good or the larger good for the greatest number of people. So that's point number two. However, what it does with respect to the interplay between the judicial role, particularly when the constitutionality of such a project is escalated before the court, and allowing such a project to roll itself out during the pendency of the question of the constitutionality, is something that perhaps we may lose sight of, because what's going to happen is, if you get into an economic analysis or a socio-economic analysis, there is a decent chance that Aadhaar proves itself to be a system which is slightly more robust or much more robust and much more efficient than any other system that was in place for, let's say, disbursement of incentives and benefits. But can that be an excuse to brush aside the questions of constitutionality that this particular case raises? I'm not sure of that. And perhaps because I'm a lawyer, I'm obsessed with it, and there are people who are the beneficiaries of it who might say that you can be concerned with the law, but I'm concerned with the access to benefits. So I think each of us has our own pet peeves, but we need to be able to separate the two. One cannot be the basis for finding fault with the other. Each of it has to be addressed on standalone merits, is my position.
Right. Nikhil, does the verdict at the end of the day, moving ahead now, allay the fears of those people who are concerned about privacy, those who are concerned about giving out their data?
Yeah, so I will again come to privacy later, because I'm amazed that people, and this discussion to me is indicative of that, people who have very intelligent, well thought out, sensitive views. Today, and we are saying 0.27%, we are taking, the court is taking for granted what has been given out and dished out by UIDAI, about 99.7 versus 0.2%, and we are doing the same without applying our mind, without being there on the ground, without seeing what it means. And I'm not talking about exclusion of those who don't have Aadhaar, which is what the court addressed. I'm talking about the exclusion of those who have Aadhaar and who are beneficiaries selected by government and not getting their benefits. There is a figure, last year over 100 crores of Narega wages were not paid to workers who had worked and who had Aadhaar, because their money went into Aadhaar based payment network and went into accounts they can't find. Would any of us be sitting here quietly if we didn't get our wages? And this is 100 crores in little amounts, but they don't matter, because we are thinking about a social justice, something we think is more efficient. In law, would we say that, okay, if we were catching 100 criminals and another 40 also get killed by the way, it would do? That's what's happening with these people. If you cannot authenticate yourself or get it through that, you are penalized by hunger and by a death penalty, because you cannot get your benefits of food and rations. That's what's happening. And the Prime Minister is saying in Parliament that this is the benefit. Because you have not transferred it, this is your saving. Have we had a single FIR filed with all those savings? That must be stolen, all those people. You should be filing FIRs against them. You should be examining who has not got their benefit due to this. And we are doing that on the ground and bringing it up over and over again. 20% of NFSA beneficiaries means 20 lakhs in Rajasthan. 1 crore people are not getting their benefits month after month for 1 year. Do we answer for them? Are we willing to? And actually not. The truth is, we have two classes in India. One said tomorrow, if we had to suffer by putting our biometric before getting into the airport and told you can't catch your flight, there would be a different story. If we were told you can't get into your bank because you can't put your biometric is not working, there would be a different story, and there is a huge class bias.
Okay.
Here and in the court.
I think the others also want to come in on the debate one at a time. Yes, Deepak.
So I come from a lower middle class family, and for the better part of our lives, we have only survived on ration food. I've actually stood in those queues as a kid, so I know what it feels to be in that particular position. So my views certainly don't come from elitism. Point number two, I respect entirely what Sir has said, and I understand that for a person who's actually feeling the pinch of the system, he knows it better. But the question that I would ask myself is slightly different. If there were 60 people who previously were the beneficiaries of a particular system which existed before Aadhaar, and if 80 people today are the beneficiaries or 90 people are the beneficiaries, you can certainly say that 10 people are still left out of the system, and therefore more needs to be done. But is it your case that I'd rather go back to 60 as opposed to 90? The comparison should not be only with respect to the number of people who are left out now, but the question should be, are you able to present a case, which is to say, the number of people who stand excluded from the system despite having an Aadhaar card today is much more than the number of people who were excluded previously. That's the question. Point number two, has the court not taken cognizance of it, and has it said the 0.23 they can rot away to death and we don't care? No, the court, if the court is, that's a different question.
I'll come to you.
Even let's assume that it's 3%. The court is very clearly saying, and this is in fact from what I heard, that the court has been cognizant of the fact that fingerprints can change, that there are a multiple number of reasons that the biometric data can change, and therefore credible alternatives so that people don't get excluded from the system and the benefits which are meant for them is something that the court has clearly come out with as well. Now, this particular issue now falls in the court of the executive to see how best they come out with alternatives to ensure that if Aadhaar as it exists fails and if somebody is off the grid, so to speak, how do you ensure that he gets what he's supposed to?
Right. Implementation at the end of the day. Yes.
Yeah.
I think
Mr. Malhotra.
that direction, as has been rightly pointed out by my co-panelist, has already been given by the Supreme Court, and Supreme Court was conscious of this fact. So I think the need of the hour now will be the implement the law in the spirit in which the Parliament has enacted it, and the way the Supreme Court has interpreted it. And Supreme Court was very much conscious of the rights and the privileges which the downtrodden people of the society deserve from those who are haves in the society. And more particularly, the Supreme Court has categorically said, given a mandate to the government, please come out with a strong data protection law.
Correct.
So that the data is also protected. I think that will take care of the situation, and whenever you pass a new law, definitely it takes little time to crystallize and see that everybody gets its benefit. There will be implementation problems, and I am just highlighting one more issue. I know I had a discussion with the person who was responsible for implementing this particular law, Mr. Nilekani, when he said that Aadhaar is not a card, it is a number. But what is happening today? It is being used only as a card. The moment you say it is a number, number means you just give your number to the person from where you have to take your services,
Right.
and he will get all the information about you, and he will come to know that you are the person who deserves this information. But that is not happening. So this is why it is not happening. It is because of the laxity or defaults in the implementation of the policy, and nothing wrong with the Aadhaar as such.
Okay, nothing wrong with Aadhaar. It's the implementation where the problem really lies, is what the panelists are suggesting. Nikhil Day doesn't seem to agree with that point, but
Now do I completely
it's
say that Aadhaar is completely okay?
Fundamentally, it's a fundamentally flawed technology thrust upon the people. Technological options also say that you should allow the best technologies in each area to function.
Right.
So I'm not anti-technology. Biometric, why not localize biometric within that machine? Why should I be connected through internet where I'm having to go back 5 times to a shop or not getting it at all? But no, Aadhaar has to be that particular framework. Why not smart cards? Why not other forms of technology? Because we have a structure that wants all the information together, and other people are paying the price for it. It is something I would invite all my co-panelists, please come to Rajasthan or to other places where we can, and spend 2 days. Then let's meet some of these people and see what it means to their, and not small numbers, huge numbers.
right. Shubham Bhattacharya, who's going to be affected the most by this, do you think? Fintech firms and payment banks?
No, that would be there, but I think the biggest thing is this is the largest database that's been created in the world, which has been certified okay as far as the legality of correction of such a data by court. I mean, from the court's point of view. I think in the 21st century, this is going to have a ripple effect across countries. I think this was being looked at as a test case, and I think there are going to be huge ramifications of this going forward. In which way is difficult to say, but it is a judgment from India that's definitely going to be studied very carefully.
I want to hear your thoughts, Mr. Malhotra, on the money bill route which was used on this. Desai Deepak brought it up. We're out of time on the program, so very quickly your thoughts on that.
Well, I think he has rightly pointed out. In fact, I will, on this particular issue, I will agree that probably there was a possibility a better debate could have taken place had it not been named as a money bill and had it gone to the Rajya Sabha. But now, since a verdict has been given by the Constitution bench that it satisfies the requirement of a money bill, and Supreme Court has given its stamp to that, I think there is no issue of debate so far as this particular bill is concerned. There are many other issues also concerning the money bill. There are many other bills which have been passed through the route of money bill, and probably they are again in challenge before the Supreme Court. I think in some other case, Supreme Court may rule otherwise. We don't know.
Is this the last we've heard of this particular issue, or do you think that it's going to come up again?
The one good thing, if at all there's a silver lining that I'm forced to look at, would be that right to privacy has come as a consequence of the Aadhaar petitions only. That's point number one. Point number two, I don't think we've heard the last when it comes to this particular issue. Perhaps there could be issues that arise out of implementation.
Right.
That's point number two. Point number three, in light of what the court has said with respect to the provisions that have been struck down, with respect to the provisions that have been read down, perhaps there's a chance that someone, let's say perhaps more creative or maybe creative, just looks at the other provisions and sees if the rest of the provisions satisfy what has been set out in this particular case, because I'm not sure all the provisions have been basically challenged.
I'm out of time,
This
Mr. Malhotra.
issue is again pending before the Supreme Court
Right.
with relation to Finance Act 2017, where a schedule was added and terms and condition for
Okay,
appointment
I'm
to
sorry
the
to
tribunals
interrupt,
was-
but I'm completely out of time today, so I have to call it a
you.
wrap on that note on this edition of The Big Picture. Thank you to everyone for joining me on the program. See you again next time.